Recording? There you go. Thank you. Call the meeting of the Interstate Cemetery Board to session. We'll start out, as we always do, going around introducing ourselves. I'm Mark Pattison. I'm representing Secretary Rosado as the chairman of the board.
Paul Ambrose, representing Commissioner Howard Zucker of the Department of Health.
Jill Faber, representing Attorney General Barbara Underwood.
Great. And?
Louis Polishuk, Director, Division of Cemeteries.
Chet Butkowitz, Assistant Director, Division of Cemeteries.
Tony Malillo, Council Cemetery Board.
Great. Okay, so let's get going. We have distributed the minutes from the last meeting. Any comment on the minutes?
I did not have any.
No comments from me.
Spectacular.
What?
2 weeks in a row.
Paul, I'm almost
You guys
offended.
did such a great job.
Well, these are small wins.
Yeah, right.
There was not much going on at the last meeting.
And since we have the video, we can
Oh,
transcribe
is this as to
Minutes.
both the regular meeting? Right, good point.
Yes.
Regular and special?
Yes.
Right. Okay. No comments on either, so I'll make a
Tony,
motion.
you will thank me for not including your casual council comment.
Good job.
I was tempted.
I have a motion to accept the minutes of the regular meeting, the special meeting as presented.
Second.
All in favor?
Aye.
Minutes accepted. Now, I said earlier that we tried to make some arrangements to get on the phone with Mr. Bethel, who represents Beverly Hills.
Beth Moses.
Beth
and
Moses, I'm sorry. He has some, he's in the middle of a collective bargaining agreement. He said he'd come out at 11. We will call him a little bit, or warn his office a little ahead of time. Is that the way you want to do that? So just put it on the table.
And I'll go out and have a drink.
You can stay, and you can.
I can stay like that.
Okay, so next issue is the issue of legislation, pending legislation, rules and regulations.
Yep.
Tony?
One of the two bills that passed both houses has actually been signed by the governor. This is the bill. It's Assembly Bill 5784-B that prohibits standalone mausoleums and columbarium that don't provide burial services either on their own grounds or with another cemetery. That was just signed this past week. Other than that, nothing to report.
Okay. Louis, you've got some
Sorry, I'm ready.
division reports?
I do. I have two things to report. First thing I have to report is that three things to report. First thing I have to report is I've finished taking notes on what Tony said. Second thing is that the NISAC had its annual fall conference at the Sagamore in Lake George. I was unable to attend, but we were represented there, and Alicia, and did Len come at me on this? Where's Dave? Dave's not here. Len did come. So Leonard Breen and Alicia Young. Len was sort of a last-minute substitute. We were going to bring Mike Seelman out from Syracuse, but Len could practically walk to the the Sagamore from his house, so it made more sense resource-wise to have him come. It's his territory, so they both spoke at the event. I think things went well, and we are working with NISAC, or we are waiting on NISAC. Their Oneonta Regional, which usually takes place the third weekend in October, is not taking place the third weekend in October, and we're hoping that they'll get rescheduled and we'll attend because, for whatever reason, that region of the state has a lot of cemetery volunteers who are really interested in what goes on, and that regional meeting ends up usually being very substantive and very helpful for all concerned. So we're hoping we'll be able to attend whenever it gets rescheduled, preferably not in the dead of January. But that's number two thing. Number three thing is that there is relatively recent. I say relatively recent because it was signed last year. Legislation. This has been talked about, I want to say going back to about a decade, to allow non-sectarian burial societies, to allow cemeteries to reclaim graves purchased by non-sectarian burial societies. So reclamations started back in 2003, November 8th, 2003 to be precise, whereby cemeteries could, after a grave is not used, not visited, kind of left alone, as defined by statute, for a period of time, 75 years if nobody's around, the cemetery could go through a legal process to reacquire them. That statute specifically exempted graves owned by burial societies. This is mostly, although not exclusively, a phenomenon of New York City's of the New York City area's Jewish cemeteries, where the first thing that people, in many parts, Jewish communities in the United States, the first thing the Jews did when they came here is buy a cemetery plot. In New York City, for various reasons, they tended to buy a chunk of graves in an existing cemetery rather than found their own cemeteries. Most of these sections are not held by religious organizations. They are mostly associations of people. They're either a sort of a social club, associations of people who come from a certain area. In some cases, they are by occupation. Some of these no longer exist, but there was a Jewish Postal Workers Society. There was a Yiddish Actors Society. And it's those graves in particular, although there are other types of societies, that this legislation was set to, was designed to help. What's happened over time is that there is a procedure for societies to liquidate via an entity called the New York Liquidation Bureau, which is a non-state agency that operates under the aegis of the Superintendent of Insurance and liquidates insurers. These burial societies are, for very technical reasons, considered for very technical reasons, is considered a contract of insurance. So that's how they ended up there. Not everybody goes to them, either because the people don't come in, the records are lost, or for whatever reason. And at some point, many of these societies just simply cease to function. There are chunks of graves out there that people would use if they could be bought, but because they've already been sold and can't be reacquired, they're left in limbo. We get calls every now and then from family members who says, you know, my father and my grandparents and my mother were all buried in the Minsker Society at Mount Judah Cemetery. How do I get a grave there? Well, you can't, because the Minsker Society, even though it no longer exists, never formally liquidated and still owns those graves, and there's no way to get a hold of them. This legislation would allow Mount Judah Cemetery, in the wholly fictitious example I gave, to reacquire the unused graves in that society, subject to a bunch of statutory constraints, which are different and actually in some ways less strict than reacquiring individual graves. We have, over a long period of time, after many discussions with NISAC, with the affected cemeteries, and with council, drafted guidelines for what we will be looking for in an application to require graves numbers. Now, let me be clear, these are guidelines. Under the statute, you can come in with whatever application you want, and we will review it. If the deviation from the guidelines isn't a matter of statute, we'll still take a look at it. It's going to probably take longer. We may have additional questions for you. We may not. We may find reason to reject it, but these are just guidelines to try to give people an idea of what we're going to be looking for in the application, although much of it is based on the text of the statute itself. So we don't really need you guys to act on this. Our goal is to put this out to give some people some idea as to what we're up to on these. The other thing that I'm asking here for discussion, and this is summarized, I had a cover memo about this that I think was circulated to the board that should have come with this, and I'm not seeing it here. That is not that is the cover memo. Wait, that is not the cover memo. You didn't circulate it. No, that is the cover memo. It got kind of merged together. That's fine. I see. So the guidelines begin on page 2. The first page is the cover memo. It's stapled together so it looks like it's one document. It wasn't originally one document. This first page is really only intended for the board, and the rest of it is what we would be sharing with the public when we promulgate this. Not that this isn't a public document, it's just, it's not actually part of the guidelines. So there are a bunch of functions that the board has delegated to the division to do.
Or not.
Well, we'll get to that in a second. There are some that they definitely have. The most notable one is the review of cemetery service charges. That by statute is the board's function. Sometime, I forget when, but I have seen the minutes, this board said, we're not going to sit here and read the numbers on these cemeteries anymore. The division is going to do that. There is a formal delegation when we review service charge applications and sign off on them. There's a stamp at the bottom or a legend at the bottom saying delegated by the cemetery board to the division. There are several other functions that the board clearly has, in fact, if not in the minutes, delegated to us, namely reviewing cemetery annual reports. The board does not typically review 1,725 cemeteries' annual reports. We do. Collecting the vandalism assessment fees. Chet does that, not you guys. Reviewing cemetery rules and regulations when they're revised. Again, our investigators do that. We do not bring them to the board's attention. I've never seen a formal delegation on that, but we've been doing it for years. And reviewing one-off service charges. This could be winter burial charges. This could be something else that's not on the price list. In addition to reviewing service charges, we review these one-off charges. I'm not 100% sure that those were part of the formal delegation of the division, although it would make sense that all service charges go together. I spent a lot of time reading old minutes. When the reclamation statute came out in 2003, the board actually reviewed applications for about a year and a half. Then in May 2005, the board reviewed an application, and then the review stops. There's no indication in the minutes saying we're delegating this to the division, but I went for a couple of years after that of minutes, and I did not see a single reclamation application, which leads me to believe that the board at that time delegated that to the division. So I guess I'm asking you for two things. One is to confirm that, and two is to clarify that that includes, to the extent it's necessary, to clarify that includes these as well. Really, the reason behind that is these are very cemetery specific, sorry, this should be silenced. These are applications that really don't have they don't even have, Jesus Christmas. Oh, that's what this is. My kid's school is having a lockdown drill, and they're going to call me now 5 ways to Sunday to inform me that the lockdown drill has started and that it has ended. Because if we call the school during this time, they So these kind of reclamations really only affect a small number of grades at each cemetery. They tend to involve issues of society-type dysfunction and tracking down people that we do, working with the Liquidation Bureau, and been doing for years, when people call us and say, hey, what about my grandfather's grave in the Minsk-Pinsker Society? We try to help them find the relatives, try to find the records, try to encourage societies to bring in. It's not something the board has done since I've been here for the last 5 years. And I don't think it makes sense for you to be sitting here and doing that. Mm-hmm. So I'm asking that you send that our way. As with anything that's delegated to us, we can always bring it to your attention if we think there's an issue for decision or just for information if there's something of broader intention. Now, I'll let you say your piece in a sec, but I just want to say to council, we had a discussion with council who I think had an excellent suggestion. It's going to take us a little while to implement this, but as to the functions that have already been delegated to us, we don't really report to you on them. Mm-hmm. We don't tell you we've approved 500 rate applications and here's the list on a regular basis. We really ought to do that. And we have all the information. It may take us a couple of months just to figure out how to come up with a format by which to report it, because I'm not going to sit here and read all the rate applications we approved, because then we'll be here all day. But with our new database, we should be able to do that relatively easily. And I think that's an excellent idea. And as part of any delegated duty, I'd like to, at some point in the near future, start providing you with a written report as to those things we've done in your name. Y'all ought to know about them. Anyway, that's my two cents. I guess maybe we could take this in pieces. Maybe I can see if you guys have any comments on the guidelines themselves. Oh, I should say that NISAC doesn't like 3 aspects of our guidelines. They don't like the fact, so there are 2 ways this can get triggered. One is there's a statute that says that if you can't find a society signatory and you've got a burial coming, and you got any old evidence that the person's entitled to, I'm obviously speaking in lay terms, you got any old evidence that the person's entitled to burial in the society section, the cemetery can allow it. They'll typically call us and we'll send the cemetery a letter saying, we're not going to ding you because you allowed this burial without the sign off of the society. In society graves, the society officer has to sign off on a burial and has to sign off on the monument. When they can't find them, but they have a piece of paper from the Minsker-Pinsker Society saying, I have grave X, they can call us. They call the cemetery. Really, the cemetery doesn't need to call us, but they do. And I'll send them a letter saying, yeah, that's fine, go ahead. Well, it says, we're not going to penalize you if you do this. And they go ahead and honor it. When that happens, that can trigger a right for the cemetery to go ahead and reclaim the society's graves. That's one way to trigger it. The other way to trigger it is if the cemetery decides to send them a certified letter asking them for, let's see where the language is, asking for their officers, where is this?
Actually, it's routine mailings.
Right.
They come back.
If they send them a routine mailing, regular mailing, not certified at this point, is returned to sender. If they send them a mailing, then we say they have to send them another mailing by certified mail, and if that comes back to sender, it's triggered. They seem to think that because the statute says they may send the mailings, and if they send the mailings and they come back, they may send them another letter. They're arguing that that language is permissive and not mandatory, and they can go ahead and reclaim it just on the first letter being returned to sender. We really don't think, first of all, we think that's wrong. Council thinks that's wrong as a matter of statutory interpretation. I think it's silly that to reclaim several hundred graves without sending another letter by certified mail, given that the burden of sending a letter by certified mail is a couple of bucks and maybe a week's loss in time, a week or 2. That's number one thing they don't like. Number 2 thing they don't like is that we're asking them not, the statute requires them to contact anyone who is engaged in proprietary activity on behalf of the society. The statute does not contain a temporal cutoff. We're asking them to go back 20 years. And we're saying if before 20 years, more than 20 years ago, we don't really care about that in the typical case. The idea being many of these societies are run in the family, so to speak. And by going back 20 years, it's roughly where you would catch the previous generation if they're still around. So let's say grandpa was handling it, turned it over to the son flakes, grandpa is still alive, that might find him. Also, with some of these societies, they haven't been active since the late 90s. That's more or less, there's sort of an inflection period of roughly 20 years ago where a bunch of them went dormant, and this would require them to go back to then, but not farther back to try to catch the people who are acting on their behalf. We actually think this is making the statute less burdensome, but they would like it to be shorter, but they haven't really told us how it would be shorter, like 5 years, 1 year, whatever, because with some of these societies, they have no current contact. So to use the last contact may very well be going back 20 years. That's number 2 thing they don't like. Number 3 thing they don't like is we're asking them to make a reasonable search, not involving genealogical research using paid services. Just look at recent burials, look at the names of the people you've got in the society, try to find if you've got any info, look online, try to find if you can find somebody related to these people who you can write to and say, hey, we're going to grab all these graves, do you have the records? We specifically don't want them to do the kind of genealogical research they're doing on regular reclamations where they actually they pull wills, they look at family trees, things like that. We don't want to go down that route. We simply want to say, here are people who are active in the society, using publicly available information and what you have in your records, take a crack at identifying them. Again, they've registered some objection to this. They haven't really given us an alternative suggestion other than not requiring it. The statute specifically says there's supposed to be an affidavit detailing their efforts to find people, so we'd like them to do that. If there's a dispute as to whether their effort is, again, these are guidelines. If they make some effort, but it's not exactly what we said in there, but it looks like they've done a reasonable job, that doesn't mean we wouldn't approve it. The point is to make them do a search that's diligent under the circumstances, and this is the best we could come up with describing how to do that. I think it's just really important to get this going because I do get these calls from people who want to be buried with their relatives, and they can't because these graves have been in limbo, and the cemeteries, absent some guidance, don't want to attempt to reclaim them. Mm-hmm. So that's the substantive piece of it. I guess I wanted to ask whether anybody had comments on like the nitty-gritty of that, and then we can talk about the thing, because I think then we can take a step back, and if you want to talk about the delegation issue.
Right.
But, again, this is pages 2 through 4. Any thoughts on that piece?
Well, what's the status quo or status of, we often talk about a lot of our cemeteries are all volunteer, small organizations. How much of a burden on the look back is it on them are they ones that have burials? So they're not the places that it's largely it's New York City and.
It's extremely unlikely that any of the volunteer-run cemeteries are going to be involved in this at all. If they were, I think we certainly could work with them to discuss what's reasonable for them, because what's reasonable for them may very well be different from what's reasonable for a big cemetery with a large paid staff.
I mean, I guess this is related to Mark's question, but do you have any idea, or does somebody have any idea, how many cemeteries does this potentially involve? How many societies? What's the scale of this?
I don't have a count on societies. Somebody did do a count of societies once. Richard, do you remember the number?
No. But it
It's
affects
in the
a lot-
thousands.
A lot of the Jewish cemeteries in the metropolitan area.
It's in
Almost
the-
all of them have society.
Richard, do you want to identify yourself since you're talking?
I'm Richard Fryman. I'm here today on behalf of Beverly Hills Cemetery Corporation, but I have clients who that are Jewish cemetery. Mount Judah Cemetery is one of them. Thanks for the fictitious representation. But
The call I got was a different society, but it was in Mount Judah.
fine.
That's
But
why I
a lot
thought
of my
of that.
clients have society grounds, and they have this problem. There's a lot of graves there, and we don't have any other graves to sell.
Yeah.
And they have a lot of graves there that are going unused, and nobody knows how to contact these societies. They're all gone.
It's not entirely Jewish cemeteries. The two non-sectarian cemeteries, and there are three non-sectarian cemeteries I can think of that are very interested in this: Greenwood, Evergreen, and cemetery. What is it? Never remember if it has an S at the end. The one in Brooklyn, and Cypress Hills, also in Brooklyn. All of them are relatively full, and all of them do have non-sectarian societies, not just churchyards, although they have those too, within their grounds that they would like to be able to get back and resell.
So these cemeteries do they know how many graves were originally allotted to a particular cemetery, or are they not even sure?
So they know what they always, or almost, if they don't know the following, they're in big trouble. Mm-hmm. They always know how many graves they've sold. Mm-hmm. They always know how many interments they've made, and they will almost always know whether there's a reservation for a spouse, because either there'll be a double stone or from the layout it'll be obvious. The piece that they won't always know is whether somebody 30 years ago reserved a bunch of graves for somebody. Mm-hmm. And societies work in different ways, and I think council and I haven't quite gotten to the bottom of what exactly ownership of a society grave means. But the typical society treats the purchase of a grave as a reservation of rights to use that grave, which means there are different permutations of it. This is the most typical case, which means I, Joe Society member, have a right to this grave or the other grave. But if I'm gone, those graves don't go to my family. Mm-hmm. They were reserved for me. They're still the society's graves. If I'm not around, the society can give them to somebody else. There are other societies that work differently, where they specifically will deed a grave out where that belongs to someone. But even in that case, those records of who has a reservation or even a society deed aren't necessarily recorded with the cemetery office. So the statute actually has some safeguards on this. The cemetery is supposed to leave aside a certain percentage of the society's graves on reacquisition to make sure that if they don't have the records when they do the reacquisition, to make sure that if somebody comes out of the woodwork, they have a place within the society grounds to put them.
So that
I can tell
reservation,
you, so just to clarify how I think it's meant to work, which is that when there is a burial society section, it's a cemetery within a cemetery. So the larger cemetery's rules and regulations still apply, as does the burial society's rules and regulations for its lot. And so when it deeds burial rights, it should have the same effect as the larger cemetery deeding burial rights. That's why the statute says resale of graves is illegal unless a burial society is the one doing it. That should be the way it works.
But in practice, many societies don't work that way.
Yeah, right. So that's an issue for us. But I agree that I think cemeteries always know what they've given to these burial societies, because both sides are very careful not to intrude on each
There's a
other.
fence around it.
Yeah.
okay.
Not always, but often.
Yeah.
And that reservation that you referred to, does the reservation involve I'm paying and I have evidence that I paid for?
Sometimes it does and sometimes it doesn't. And oftentimes the evidence is just gone because it was done 40 years ago. The society officer who did the reservations died. When the family cleaned out the estate, they just threw out the records. The person for whom the grave was reserved got it 50 years ago, no longer has that piece of paper, and everyone's in limbo. Where we'll have a burial is somebody will have a receipt still, even though the society people can't be touched, and it can't be found, and where you have that receipt, even if it's like a canceled check, a scrap of paper, pretty much anything that shows where the person should go, the cemetery is within its rights to honor and allow the burial.
I think sometimes societies didn't actually sell the graves to their members, but actually the members got a grave as a benefit of being part of that society.
There are some where they don't actually charge. That's absolutely true.
So, which really points up why we're being so careful with the guidelines. It's you're possibly taking away someone's right to burial. And with the reclamation from an individual or a family, there are a lot of hoops to jump through, because you're taking away that individual or that family's right to that grave. And so this reclamation, you're taking a chunk of graves.
Yeah.
Not just one or a family of blood. You're taking a chunk of graves back. And so the guidelines are so detailed and go back so far in time for contact because of that, because we want to make sure that the cemeteries avoid as much as possible having an issue where someone comes forward after they've done a burial for someone else and saying, that was my
Yeah.
grave. So that's one of the reasons why it's so detailed.
And what would happen in that case?
Well, in the society ones, they're actually supposed to leave a certain percentage of the graves unsold.
Right.
Right.
And the reality of the matter is most cemeteries are not going to sell out an entire society section, even if they successfully reacquire it. There's always going to be a couple of graves left. There are probably one or two where that's not the case. I'll bet in Old Montefiore there'll be societies that sell out like that when they reacquire them. But most cemeteries, they're not going to, there's always one or two left on the grounds. And they would be able to accommodate the few people that came out of the woodwork that way. It wouldn't be necessarily be the right grave, per se.
I'm just trying to figure out, what if we get it wrong?
Look, my guess is the cemeteries, if they're not full, will make a grave available to the person, period. If the section is full, but they have a grave elsewhere, I'm guessing they'll just give them a grave. They typically, when you have a situation, I'll give you some analogies. That's actually, isn't that required in the reclamation statute? In the regular reclamation statute?
I'd have to look.
Yes, it is. It is. It's never happened. It's actually never happened, but the reclamation statute specifically says if somebody comes out of the woodwork and it's all been sold, they have to give you a grave. That applies, I think, I see no, not having looked at this particularly when I read the amendment, I don't see why it wouldn't apply. This amendment is within the regular reclamation statute, and pretty much everything other than the particular hoops you have to jump through applies.
Unless
There's a different list of hoops.
Unless there's a reservation for a spouse or a family member,
Mm-hmm.
is the graves just made available in the order of?
Some do it that way, some don't. That was sort of the old school way of doing it, is they would just do it with what some of the cemeteries call military style, where you
Right,
just
right.
get the next one. There are societies that work that way, so if you go and look at their graves,
Yeah,
you'll see all the dates are,
yeah, that's exactly
order.
how it's pictured, yeah.
but that's not always the case. Some of them, because people want to be together with their family, whatever, will have one here, one there, one everywhere.
So if they were given a grave, that would be a single grave, and the desire would be to have a spouse buried adjacent to them. That's,
It's all
sorry.
different. They're all different. They're all different. So in some societies, that would have never been that wouldn't have necessarily been guaranteed in the first place. In others, even if they did guarantee it, if nobody was in the ground yet and they did reclaim it, yeah, if one was in the ground, it's possible. Usually, when you have spouses as opposed to parents and children, they'll either be a double stone, or you'll see that they skipped a grave when they assigned them, if it's long enough ago. So in most cases, spouses are going to end up together regardless. And right now, the children can't even get in at all, so getting them in somewhere else in the society grounds is better than they can't get there at all.
So this is a statute which we are providing, not regulation, but guidance.
Yes.
That helps clarify how we will review applications.
Right.
And hopefully gives a streamlined pathway for that review. Is that?
Yes.
and the guidance can be changed if things aren't working out the way we anticipated.
And the very last section of the guidance says just that.
That was Tony's addition. He's absolutely right. I mean, we anticipate, what I really want is for people to start submitting applications, because I anticipate that once we've gotten them, I am sure we are going to make changes to this. It's not even a question. I'm 100% certain that we will tweak this in some way once we see real applications.
And I guess in terms of the publication requirements, so I'm looking on page 3, number 3 and 4. How much does the division, because those are things that the cemetery itself needs to do, correct? Number 3 and 4 they post. I mean, do you give any guidance? I mean, I can see, problems depending on what the cemetery chooses to do and how they choose to interpret that, whether it's realistically calculated to, give people notice.
I have not, in doing regular reclamations, I've not seen any abuses of
Okay,
this.
okay.
I mean, with society one, look, realistically, we're talking about Jewish societies, so realistically, you're talking about advertising in one of the Jewish papers. Because people actually read the legal notices in those, believe it or not.
My wife reads legal notices in the Post that I buy every day.
Okay, so again, the board's role is you're informing the board of this approach
As to the guidance,
as
yes.
to the guidance, and so it's good for us to understand how the division is approaching that and what the issues are. Are there any other questions in terms of just understanding the policy that the guidance describes? Okay, so the other question is about delegating the responsibility to the board. And Tony, do you have an opening review?
So in my time on the board, I've seen the board delegate the power to review rate applications. And in fact, the first 2 years I was on the board, that took up a lot of board time. There's a lot of minutia when you review rate applications. And especially because sometimes they'll throw in a new rate that they didn't have before, and it raises all kinds of questions. And initially what the board did was direct division to come to it with anything unusual. And for a while, division did that. And you guys haven't seen a rate application, any of you, since you've been on the board.
It's
So-
rare that we get anything unusual.
Yeah, division's basically taking that delegation and has run with it. But hopefully, since Lewis is on board, you will at least start seeing a report of what's being approved. And then the other thing I saw was when net appreciation was passed, division asked about delegating that to division. And what the board decided at the time was, let's look at these first for a while. And once we're comfortable with the process, then we can decide whether or not to fully delegate it to division. So, one possibility for the board is to take that approach, is to have division have this first view presented to the board, just so the board could see how it's going. And then at that time, decide to delegate. Because I could see this, I don't know, it sounds like it's going to be quite a few applications. It sounds like there are a lot of cemeteries who are very eager to start this. So it probably is wise at some point for the board to say, division, this is all yours, but whether you do that now or do that after you've seen a few is something to think about.
Now, the issue I have, which again, this concerns a different board, mostly. Paul, you might have been there for a few seconds when this happened, but mostly these are different people. But what I'm hearing from the cemeteries is the net appreciation applications took so long that they basically, nobody's doing them now, partly because of the delay in getting something before the board. And I've had a bunch of cemeteries say, if this has got to go to the board, not you, we're just not going to bother. I don't know if that makes any sense, but I've been hearing that from a lot of people. And again, this is that they're not going to bother trying to reclaim Society of Graves if it has to go to the board. And the issue, the thing is, a lot of this is just about the minutia of societies and finding people. That's something we do, especially together with the Liquidation Bureau. It's not something in my 5 years I've ever even had to explain to the board until now.
Well, it seems to me
Almost my 2 cents.
the key of, it makes sense to me to delegate the responsibility. I think what's aside of that is the rapidity of the reporting, right? So early on, I would say it might be that we need more regular reports about how that's going. Whether that's, I don't know what that is, monthly.
This I can give you
I know you can, but I'm just trying to describe the concept, which is the concept is we delegate responsibility, but have increased monitoring. Ask the division to report to us each month about, or every 6 months, or whatever the right pace is, so that we can, kind of keep an eye on it, right? Rather than do them for the first 6 months. I mean, that's, I don't know that I really want the board getting into that, but I do think that it's wise for us to keep an eye on how that's going.
Let me make a suggestion. Like for the rate applications, I'd probably just give you a list. We approve the following. For this, we could give, every time we get one of these at the monthly meeting, we could give you a one-page summary of what we got, what we found, and why we approved it.
Suggestion. I think Tony makes a suggestion that we do some to get the feel of it under our belt. That's a reasonable suggestion. Another one is that we firmly delegate the responsibility to the division, but establish a reporting cycle, which can be changed over time. You might say, well, we only need that annually or whatever else is there. Just get to sort of the larger picture. I think one of the other things we ought to consider once we go through a process of looking at the information Tony sent out about board duties and responsibilities, is there seems like there's certain places where we've effectively delegated responsibility without necessarily officially doing that. We should probably go back through, make sure that's officially done. And then I don't know what the right, again, period is, but that's probably something that ought to be like reissuing executive orders every time there's a transition. There's some period by which we say, here's the list of things we delegated, let's confirm or take back that on some annual basis or some whatever is the right period. So, or whenever, I don't know, whenever there's a change in the board structure. I'm not really sure what the time is, but we should reaffirm those. We should confirm and then reaffirm those delegations. In my view.
And then I guess, being mindful of the comments that you've heard from the society saying, well, if, you know, these go before the board, we're just not going to do the reclamations. I mean, I think it's something we need to be mindful of. And so I guess, you know, following up on what Mark said, I think that having the information about, you know, when the applications come in and, you know, what action the division is taking is important. And my assumption is that if in evaluating that information as a board, we think, you know, we want to change something, we could always invoke that
Right,
at that point. But I think that it's not, I mean, unless, tell me what other people think, but I don't know that it's, that we gain very much by having it an official board duty
Right.
to
I agree.
preside over those. As long as we're getting the information and we have the opportunity to, you know, be involved in the process if we need
Yeah,
to.
we always can take it
Yeah.
back, and we can always also request the division change the guidance if somehow that comes up.
Could I borrow that for a second? Just,
What do you need?
1513 edge, what, they're called reacquisitions under the statute, if I remember right?
Reacquisition, a lot of.
And does it say that they're applications? How does it characterize them?
They upon application approved. by the
Applications, thank
Cemeteries
you.
Board.
So do I have a sense, I mean, again, I don't think it's a vote. I guess there's a vote. on the
I have a
delegation.
motion.
Go ahead. Put it on the table.
I tried to make it simple since I didn't type it and give it to you in advance.
Okay.
The motion would be to delegate to the division those powers conferred on the board by not-for-profit corporation law, section 1513-A, concerning reacquisition of graves. The division shall report blank, I'm leaving that blank for how often you want it to be, on actions taken on such report to the board, monthly, quarterly, on on actions taken on such applications.
Okay. I would propose monthly for the first year.
Yeah.
I mean, I don't say that, just monthly, I guess.
Which would also include regular reclamations, which I don't think is necessarily a bad thing because it'll help. Because
Again, we should have a schedule of reporting things.
Yeah.
Delegated. That's a motion. Is there a second for that motion?
Second.
All right, any discussion about it? I mean, is there any, seems like we're okay. So we are informed about the guidance can be issued. All in favor of the motion to delegate the responsibility to the division as long as we get monthly reporting as per the, all in favor?
Aye.
Aye. Motion carries.
Cool.
All right. So,
David, I wrote it down.
so again, just doing a little timekeeping, I had told Mr. Bethel that we would talk about 11. We have Beverly Hills on the agenda ahead of them, but we could swap it around if you have any objections.
probably call him.
He did want a little heads up, so.
Fine. Sorry. While Chet's dialing, I'll just remind everybody that I've recused myself from anything concerning this matter.
Yeah. Turn
I'll have a
on,
number. Hit this. And
212.
such recusal doesn't involve the phone.
212,
Oh,
You don't need the one. You don't need
how
the
do you hang up?
212, 326, 0154.
Richard Bethel's office, Dan speaking.
Dan, this is Mark Patterson from the New York State Cemetery Board. We had told Mr. Bethel we would call him around 11. I know he's in another meeting.
I'm going to have to pull him out of another room. Have you got a few moments to hold?
Yes, I guess we do.
Yeah, I'm going to have to pull him out of another room. One moment.
Great. Thank you. Are we clear on, this is the Wellwood? Okay. That's mostly. And again, there's no secret here. I think that the issue here is that it really depends on what.
Thanks for holding. He's headed back to his office. It should be about another 60 seconds.
Okay. I'll wait till he gets there.
Yeah.
Yeah.
Where's my pen?
Recuse myself from a lot of things and stay in the room. So.
Oh, I can be the note taker since I can't talk.
How do we know we'll trust you?
Because David's also taking notes. He can check up on me. We absolutely have a record. Or I could go and get a beer.
We are having an audit done.
Our question
Yeah.
is the same for.
Which name was that? It doesn't give a name, just gives it a title.
Where? Which one?
Oh, shit.
Federal? Or state?
Supreme Court.
State.
Seems odd to me, too.
Josh, why don't you come to the hospital?
Good morning.
Good morning, Mr. Smith. How are you?
Good.
This is Mark Patterson, your own speaker, and also, as Lewis says, being broadcast to thousands of people who are intently watching the live streaming of the New York State Cemetery Board. So
Very exciting. I so rarely get to speak to thousands of people.
you're a rock star. So let me see if I've got this set up first. You're representing Beth Moses, Wellwood Cemeteries. The issue before us is a request to demolish the Wellwood office building. And the circumstances here are that we have discussed this previously in several years ago. At the time, we approved the first two phases of the project, denied the third, and instructed the applicants or we encouraged them to pursue some sort of resolution to the fact that there are two cemeteries that have identical boards and are operating as if they were one, but does not meet what we believe is the best interest of the. It's not about the operating as one. It's about sort of the function of the not-for-profit law. So in the intervening time, that hasn't happened. You did make some effort to pass resolutions that you hoped would address the problem, but it never came to the board. The board never acted on that. And so you're here to make a pitch for the demolition of that building. You've dropped the issue of payment between Wellwood for other expenses. And I think the board has to decide its sort of tolerance for, we understand the issue about the building, but we have to decide whether we want to really consider that as it comes back to us without resolution from our earlier meeting. So Tony, is there anything else you would say to set that, just set up the conversation?
No,
Do I do it accurately?
Yeah, I think so.
Okay, so if I wasn't accurate, please correct us, and we welcome your comments.
Thank you, and thank you for giving me this opportunity to address the board. I think what you said was accurate, as much as I could tell. But let me set this up as I see it, and I will try to be brief, and I think I will be brief. Wellwood and Beth Moses, as you know, have operated substantially as one cemetery since the 1940s. It appears that Beth Moses was established as a separate cemetery because of the 250-acre cap. Now, I use the word appear carefully because, to the best of my knowledge, there's no one still alive with personal knowledge of how that decision was made and what was decided. The arrangement, as you described it, was known to the Cemetery Board since its creation. It was reflected accurately in every document we filed with you and with the federal government, that is the 990s. It's been known to a succession of division of cemetery directors, and in no time has any division director, the Cemetery Board, or any representative of the Attorney General raised any question about this. Wellwood and Beth Moses, or rather the boards of them, are not opposed to a merger. And I think I said that back in 2015 on first blush when this was, when I was taken by surprise on this, that I personally was not opposed to a merger. Our problem is we believe it to be impractical. Tony Melillo suggested the contrary and cited me to the example of Greenwood, and I proceeded to speak to David Fleming, who handled the Greenwood legislation. And I think the precise words that David used when I called him about this was that for Greenwood, the stars seem to have been aligned in a situation which will never again be repeated. When we asked him what he thought it would take us, in the best case, to pursue legislation, he said 2 or 3 years or more. Now, the cemeteries are prepared to pursue legislation if necessary, but we don't believe that we should have to go that route. There are many separate corporations with common board membership. This is not an unusual scenario in our modern economy. It happens all over. There's nothing in 1506 that prohibits this. The cemeteries have operated at all times as they have been constituted, and we think it's perfectly proper. Now, legislation would take a long time, as I've indicated and David Fleming confirmed. It involves a substantial unnecessary expense, we believe, and most importantly, it's a long delay. The delay is of concern to these two cemeteries for a variety of reasons. We have a building which is empty. We have a building that is deteriorating. So it presents first an eyesore. It's not what we want the public to see. Number two, it presents a substantial expense, both of the legislation and insurance expense and others just to keep it up. And most importantly, it presents a potential danger to the public. We have an active cemetery with many burials going on, many visitors, and we have a building that has something like police tape around it saying stay away, and one never knows that everyone will obey that request. And so that's of great concern to the board of the cemetery. The resolutions that you mentioned were adopted by both boards and already provide for a 50-50 split of common expenses. Those resolutions also commit each cemetery to the other for facilities based on its property. So to simplify things, as I've already said and as you mentioned, we will withdraw the application for Wellwood to reimburse Beth Moses for the costs of the expenses of the expansion and the renovation to Beth Moses' building. So we can take that issue off the table and just simplify. This is about demolishing the building. And really what I'm hoping for today or soon is clarification from the board whether in its view legislation is necessary. We think legally it is not. Apparently your predecessors have not thought so, or they would have told us that, I'm sure. But if it is necessary, we would request that we be given permission to demolish the building while legislation is sought. We don't want a danger to continue for 2 or 3 years on our property. Now, in the alternative, we want to understand how you see this contract option, which was proffered by the board. We don't really understand it. If it's a matter of simply saying in a contract what's in the resolution, we're prepared to do that. We're prepared to make the terms of the contract, the 50-50 split that's in those resolutions, subject to review by either the Attorney General's office, the Cemetery Board, or both. We think it's fair. We think it makes sense. But if you think that that review is appropriate, that we have no objection to that. We're not trying to do this in secrecy. Louis Tolashuk, the division director, had led us to understand that the resolutions would suffice. I was led to believe that at the August 8th meeting, it was likely, and obviously Louis didn't control the board's vote, but it was likely the board, with his recommendation, would approve proceeding as we have done. In conclusion, we do think that the merger option is an impractical one. We also think the contract option is impractical. But really, we need guidance from the Cemetery Board. Then the boards of these two cemeteries will make a decision, will proceed. We must demolish the building. We can't keep it up in perpetuity. That would be the easy response, but it's not the responsible response. It's not something the boards will do. So we need guidance from you. That's really the purpose of my participation today, and I thank you.
Thank you, and just on the issue of previous boards, as good as they are, improvement brings new results. So we'll take our opportunity to change the view of the board today than from the past. I appreciate the fact that you've tried to work with us to simplify the issue and isolate the discussion around the demolishment of the building. And I think the fundamental issue is that without a board merger, you mentioned there are plenty of, we would in many cases encourage the kind of operations that you have, the joint operations, as efficient. But the two boards don't have common members, they have identical membership. And so it's, in our view, impossible to say that each board can represent the cemetery in its best interest. Not because we are accusing anybody on the boards of operating outside the best interest, but because the fiduciary responsibility of a board member is to ensure that the board's best interests are being maintained. And since they're on both boards, we see that as impossible. So, again, to jump ahead of the council, I think we would. First of all, if we had a plan, I think that's what we were looking for some years ago, was a plan to resolve this issue while we were dealing with whatever issues in front of us. And secondly, I think we'd entertain a discussion that had something to do with establishing sufficient independence of each board. There could be overlapping members, but there'd have to be enough independence to reasonably sure that each board could act in its own best interest.
Can you flesh that out so I understand and can convey to the boards what you are suggesting?
Well, there's a danger in that, because then you get to legal issue of what's legally the minimum requirement to demonstrate separation. I don't think it's fair to ask the board to define that legal requirement.
I don't think there is one, Tony. I'm not aware of any authority that says that. As I said, there are many boards that have common membership.
Yeah, but those boards aren't doing business together, sharing employees, equipment, funds flowing
In the
between
private
them.
sector, this happens all the time.
Right.
It's a very common scenario, and it does happen.
Again, I'm not opposed. I don't think I'm not personally opposed, but the operation of the two boards as one, to me, again, without benefit of being there, clearly was an act to get around the cap. Whether that's a good idea, operating jointly is probably smart. It's probably efficient, in at least the main. So I'm not opposed to the idea that people would work together collaboratively. The question is the sort of fundamental issues: can the boards operate within how we see the not-for-profit law? And again, I'm not sure exactly. I think Tony's right. We would not. It would have to be a separation of the boards sufficient in some, either our view or maybe in consultation with the Attorney General, to establish some sort of independence. Again, I'm not committing the Attorney General.
I'm just looking for some indication of what that means for you.
Can I just ask a,
For the Attorney General.
can I just ask a threshold question? This is Jill Faber. I'm just going to take us back a little bit. And again, excuse me if this has, been discussed at other meetings. I just didn't see this information anywhere. Have the boards submitted an application for approval of a merger either to the Attorney General's office and/or the court? Has that been done at some point?
We have not.
Okay, so I guess then my question is, the discussion of legislation, and I know that you, discussed the fact that legislation would take an inordinately long time, and for all, a host of compelling reasons, that isn't ideal for the situation that you're facing. And I guess, and you don't have to answer me, I just put this out there, I wonder whether the boards would consider seeking permission for a merger, which, in my experience, would not be a process of a number of years.
This is our problem, and let me make it as clear as I can. I agree with Tony Melillo that if this was one corporation, it would appear that 1506C would impose a 250-acre cap. I think the legislation that Tony suggested to me we pursue would be an exception to that cap. And there are exceptions to other provisions in 1506, which appear right there in the statute. So there's no question the legislature has the authority to make exceptions. We don't know what the probability of that being approved would be. The only thing we know for certain is that it would be a lengthy, expensive process with an uncertain outcome. I say that about uncertainty because a much larger issue affecting the entire cemetery industry now is sales tax, and I'm sure you're familiar with that issue, and proposed legislation has been stalled on that for 2 years. So it gives us concern that something like this, without the, all the lobbying leverage of a state association, could be stalled indefinitely. So I'm perfectly comfortable with recommending to the boards that the merger be pursued with the AG's approval or subject to the AG's approval. But I don't know that that enables us to avoid the 1506C acreage problem, which is really what I think has led us to this point.
Yeah, I agree with that.
Mm-hmm.
So if I could just give some additional background, which I think helps clarify some of the issues here. So when this was in front of the board last month, I guess it was, the issue was how urgent, one of the issues was how urgent the request was for demolition of this building. And when you and I spoke, I thought that perhaps you would be submitting an engineer's report on the condition of that building. Division has had it inspected by its own investigator, and while the interior certainly looks problematic, ceiling tiles coming down, the exterior looks solid. Now, she's not an engineer, and she's provided photographs, but this building doesn't look like it's going to fall down anytime soon. And I would just a few more comments.
Sure.
And this request was made 3 years ago, in 2015, and the board said no, not until you either merge or establish a written agreement between the two entities. So here we are 3 years later, the building's still up, but neither of those conditions has been met. And I think that goes to the issue of, well, if the building is taken down now, what is the urgency for the cemetery to finally meet those conditions, which it hasn't met for 3 years? And lastly, on what it takes to have separate entities sufficiently separated. One of the things that has troubled me is Wellwood 3 years ago, got a board order that says Wellwood doesn't have to pay $600,000 for the improvements to Beth Moses's building. And now, the two cemeteries, including Wellwood, apparently came here seeking to undo that. Now, why would the board of Wellwood Cemetery want to undo a board order that says you don't owe that other cemetery $600,000? I would love to be able to speak to the board of Wellwood and talk about that, but I would be speaking to the board of Beth Moses if I spoke to that board. And Richard, your own letter, when you talked about the fact that you have resolutions rather than a contract, admits that having a contract between the two entities is problematic because of the identical boards.
Sure.
So you recognize that yourself, that negotiating a contract when you have identical boards is not something that can be done. There has to be a separation. And one thing I would point you to, you wanted some legal parameters. I would suggest you look at cases that deal with piercing the corporate veil and what it takes. At what point a court will decide that the entities are so interrelated that they basically have been treated by the operators themselves as one cemetery, and therefore the corporate veil can be pierced by creditors. I think that would be a good indicia of where you need to avoid and how you need to come back from where you are now to avoid that kind of a claim being made by creditors. If a court would recognize these as separate entities and would not pierce the corporate veil, then you're probably in good shape. So you might want to look at what the indicia are for that kind of a claim.
So
I wasn't aware, Tony, that the piercing the corporate veil analysis has any application in 1506. I don't think there's any authority that suggests it does. It's analysis for an entirely different purpose.
This isn't about 1506, you know. This is about...
It can only be about 1506 because that's where the 250-acre limitation is.
No, this is about two entities being properly operated in compliance with the not-for-profit corporation law.
Well, that's a novel position, like I said. I acknowledge the chair's position that the board is not bound by what your predecessors since your formation have done. That's true.
I said that a little bit tongue-in-cheek. I was just a...
Well, you may have said it. I'll take it as a straight statement. It's fine.
Yeah.
But clearly, under circumstances like this, there's been very close scrutiny of this relationship. There have been countless inspections. There have been countless times when the division directors come out. No one has ever suggested, has ever intimated that there was anything improper under 1506 or elsewhere about the way these two cemeteries have operated. I don't know who made the decision back in 1941, I guess, because that was the year when Beth Moses was incorporated, to incorporate it as a separate cemetery. I can only conjecture about the reasons. The only thing I know for certain is that it's operated in the fashion it still operates in, openly, notoriously, known to everyone, reported to the feds, reported to the cemetery board, and no one has ever, to my knowledge, breathed any suggestion there was anything improper about it. So we are taken aback, by the position that is being conveyed at this point. As far as this question about why we did nothing for 2 or 3 years, let me speak to that because I think that's worth a moment or two. When I reflected on the merger discussion, and I did say openly that I would favor merger if it were practical, I went back and asked those who were still alive at the cemetery, did they have any idea why we were organized the way we were? And what I was told was a story that had been told to one of the board members 25 or 30 years earlier, which related to the predecessor to 1506. And at that point, it's the obvious perhaps struck me, which was the 250-acre cap.
Yeah.
And it was my belief, and it continues to be my belief, that the board in existence in 2015, like myself, gave no thought to that when the issue of merger came up without, in my case, and I think anybody else's case, prior awareness it was an issue. I think Dan raised that out of the blue from what I understood. and we responded appropriately at the time. But as we thought about it, it seemed to be an impractical solution. I didn't think the contract was a wonderful solution. And I did believe, and I do believe, that the resolution approach was a more appropriate one. And it reflects the way we've operated in the past, the way we would hope to operate in the future, and would operate in the future in the event of a merger.
Let me,
So I then,
I think we have the facts before us, and I'd like to move it to a board discussion. I think there's two issues before us. One is, as they propose, a cleaner request to tear down the building by having taken the money issues away. The second is what we're willing to tolerate in terms of the current status quo of two boards being interlinked. And I personally think that going to a separating the boards is sort of going backwards. I mean, I think you're exactly right. You've always operated as one. You for good or not, got around the law, the 250-acre cap, by creating two boards, and you operate as one. Great. The question is, what are we willing to say to you? And I would prefer that we had a plan to vigorously move to get the state authorization to merge, and whether that's an approval through the Attorney General or going to your legislature and getting a home rule. And Dave Fleming is much more knowledgeable than I am about these things. It doesn't seem like that big a lift to get a home rule on something that already exists. You're not expanding the footprint, and you're just confirming that. But again, I'm not. I've got a lot of government experience. I wouldn't question Dave on that. So, I would prefer we went in that direction. I would prefer we dealt with the issue of the building separately. I don't know if there's urgency or not, but I don't also see any particular reason to see it hanging around. You're not using it. So again, I'm just saying that's sort of my view. Other board members, what's your view, Paul?
I'm a little bit confused about the fact that even if they did merge, if they did merge, the 250-acre cap still applies.
No, you'd get permission to merge, and they would exceed the 250. That's what the state law. That you'd get that through the legislation, right? They'd go to whatever footprint they have now.
Need legislation.
They would need state legislation.
legislation, we still could not operate.
No, I don't. I'm not sure I follow that.
Well, let me understand that. If we merged, let's assume we went through the AJ and we got permission to merge. We now become, I don't know the exact acreage, but let's say a 400
No, it's
acre
actually,
cemetery.
it'd be actually 270 acres. Wellwood is 150 acres, Beth Rose is 120. So it's 270 acres. So it's 20 acres over the 250.
No, you would need to get state legislation to allow Suffolk County to establish a 270-acre cap or establish whatever you're doing now, in addition to the other hoops it takes to merge the board. So I agree with you that that's something that would have to be done.
So we need state legislation, not Suffolk County, right?
I think that Suffolk County is a state statute that allows them to set the cap. So again,
It's actually in the NPCO,
And these,
in Article 15.
and these are already established cemeteries.
So you don't think we need 1506 approval, that we're a way to amend 1506? I thought we
You
did,
will need
but
the
I
state
could be wrong.
legislature to act.
I'd be much more comfortable if it only required Suffolk County approval.
yeah, I don't think so. And again, I'm not a lawyer, so I'm going to
Okay.
not play one on TV.
Well, I'm happy to look into that. That would make us much more comfortable.
I think you need state legislation. You need to get home rule from your county ledge, and you get your state legislators to carry the water on that. But again, you're not asking for permission to expand. You're asking for permission to recognize the current boundaries and to cure the device that was used to get around the 250-acre cap then. But you exist as you exist, and as Chet says, it's not that much over. So I don't know the local politics of Suffolk County. You will know better than that. Again, I don't pretend to be an expert there, but I would like to see that pursued, and I'd like, that assiduously pursued. That I don't know what that means to the building. Again, I think the building, I don't particularly see any advantage of seeing the building deteriorate over a period of time. And so I'm not uncomfortable with the idea of approving the demolition at Beth Moses' expense. Again,
And Willwood's expense.
it's Wellwood's expense. Yes, it's tautological in the sense that we're arguing about something that exists in form, not function. But I'd like to see the form be cured. So
how would we go about that concretely? Because we would like to demolish that building, and
we have that application in front of us, and I think the board can approve it if they have a tolerance for doing something they said they wouldn't do 3 years ago. And again, in our view, and I appreciate the nuances you've brought to us, in our view, the board, I don't know if anybody, certainly I wasn't here then, but the board had a specific direction then, and, all we really got was a request again to demolish the building without what I feel is sufficient effort to solve the problem that was raised then. So the board, would want assurances that this was serious, that you were going to seriously pursue some sort of resolution through changing the state law and allowing you to merge the two boards.
So would that be proposed legislation or a statement that we intend to pursue, or what would you be looking for?
I'm looking for a plan, and again,
is to demolish the building.
Yeah, I understand.
The most immediate concern is the danger.
But I'm asking the board to have that conversation right now. Again, I don't know if there's a danger right now, but it's certainly an attractive nuisance. I understand your interest in having it demolished. So I don't know. Again, I'm opening this up
I
to
should
the
add,
rest of the members.
one piece of information the board should know is that an audit is being conducted at the cemetery because at least one board member raised that concern about, all the people who are receiving money from both cemeteries. And some of the numbers, when you add them up, are quite large. So, and I think the Attorney General's office has an issue right now with the proposed merger where people are making a lot of money between the two cemeteries. So that is being done. I don't know how long it will take.
Go ahead.
A couple of times.
So how should we proceed?
A couple of times you've indicated that in your discussions the idea of a formal merger was considered impractical. Can you elaborate on the use of that term? Why is it impractical?
Sure. We are concerned about the prospects of legislation. We think it will take, according to what we've been told, 2 to 3 years or more. We think, for the reason I indicated before, which is the sales tax law, which is currently pending, has been pending for 2 years in the legislature, we're concerned that we could make this application, it could just sit there. I was very interested in the chair's suggestion, but which I may have misunderstood, that we could simply get local legislation, that is Suffolk County legislation, but then I think I misunderstood initially. If that were the case, we'd be much more open to this because that's something that could move, presumably much more quickly. The state legislatures not do anything quickly. As you know better than I, it does almost everything it does for the year on or about April 1st.
But it's been it's been a number of years since the issues that we're discussing today were raised, and during that time, there wasn't any attempt to get a legislative remedy. There was an attempt to make any formal merger of the board. And so I think, to come back to the board now and say there is this, significant time imperative is really putting the burden of, quick action on the board when I'd put that back to you folks and ask if there was such an imperative in the last 3 years, why wasn't this process started?
I mean, again,
I think the quick answer is what I said before, which is we believed, rightly or wrongly, that the board as it exists in 2015, when it proposed a merger, was acting based on the misapprehension, which I shared, that there was no 1506 issue. And when I raised this with Lewis, he understood what I was saying. You know, it took several conversations, but then she came back and understood. I'm not suggesting he ever acknowledged that the board was acting under misapprehension, but he understood what I was saying. And so that was our thinking. We really thought that this was based on a mutual misapprehension.
But then you,
On my part, on the cemetery board's part, and on the Bellwood, the Beth Moses and Wellwood board's part.
but then you still have the identical board composition. You know, that, I don't believe that, you know, remedying that had anything to do with your conversation about 1506. You know, you still have, you're still asking us to approve this, you know, put the, you know, the legislation aside, you're still asking us to approve this based on an application by two identical boards.
I continue to not see legal issues there.
I think you're, no. I would be happier if I thought I was getting a response that said that you were taking this request more seriously. And I mean, to pick up the phone, I don't know how. Oh, never mind. You know, it seems to me picking up the phone to call your county legislators to see if there's some avenue to pursue, or your local assembly person to see what avenues they were willing to support, is not all that tough. But what you've done is sort of argued the law and not what we're trying to achieve. So, I mean, again, my goal would to be find a way to make every effort to find a way to get you to properly act in the way in which you are currently acting. And I don't see that as being that difficult to take on seriously. I agree that you can't guarantee the result, and I'd like more information about what the tremendous expense would be. But you know, I think we have evidence. I'm informed there are other cemeteries that have asked for expansion of their size through state legislation, gotten that in a quicker
I'd be
process.
interested in more information on that because I'm not aware of those.
We can give that to you, and we are glad to. But that's not really not the point. I think you need. I mean, I'm willing, at least I am willing, to consider the issue of the building once I get a sense of your understanding of what we're trying to achieve here. And I'm not getting that sense of understanding. So short of you representing to us that the board is more seriously willing to consider taking on the challenge of, again, if you agree that you want to act more like one board properly to get to the merger issues, then it's a non-starter. If I get some information from you that or at least the board agrees with me that that's a sufficient response, then we could go on to consider the issue of the building. We're giving up our leverage, so to speak, but I don't think that's really the issue here. We understand your need. I understand your need to get the building down. I want the cemeteries to operate efficiently and properly, but I want a more active, aggressive effort at getting this issue resolved. Now, that's my view. Again, I'm speaking for myself.
Richard, let me add,
Yeah, I'm sorry, go on.
we kind of avoided in this discussion talking about the alternative, which is to separate. Have separate boards, separate operations, and a business agreement between them. And that we have seen. And we have plenty of cemeteries that have separate boards that enter into a business agreement between them. And in fact, the statute allows, and the regs allow that. So if merger looks that problematic, and I know you've said that, well, that's going to reduce the efficiency, the financial efficiency, it's going to result in more costs if they're separate. Well, that's the nature of two separate entities. They're each going to have their own costs. And you could probably still improve efficiency by having a management agreement between the two of them. But that doesn't make it an impossibility. It is a possibility, one you're fighting against, but it is a possibility and it's an alternative. And I think you need to give that more consideration than you have?
I think the determination of these boards, and I thought I'd said it before, and if not, let me make it clear now, is we will pursue the merger if there's no alternative. I've never suggested that either option is an impossibility. I think the word I use is impracticality. But clearly we will go down that road, and I don't know what proof of that you need beyond my representation, but whatever it is, I'm prepared to request of the Wellwood and Beth Moses boards. Is there something specific you want? You want a resolution? What would you want?
Well, let me, just in terms of what Tony just asked, would the board, I know that it's, they are two separate boards, but it is one set of individuals that represent both entities. Would the boards consider, what Tony just suggested, separate boards with an agreement between the two, an operating agreement? I mean, has that been discussed?
It has been discussed. I think the general response from the board here, or the boards here, is if it ain't broke, don't fix it.
Well, if it ain't broke, don't take the building down. I'm going to kind of get close to calling the question. I've got other people here to present their case. So again, again, one of these two options is seriously pursued. If the board is unwilling to pursue those options, then I think the board has already answered the question 3 years ago about whether the building should come down or not.
I've already indicated that we're prepared to pursue the merger.
Well, the merger or a serious look at simply replacing several of the, enough of the board members on one of the boards, or all of the board members on one boards, so you have enough independence that you can have a conversation, a legitimate conversation about a management agreement between two entities. Again, what my fear is that we say, okay, you can tear the building down, and we get another 3 years where no action's been taken.
I've asked a couple of times now what, on the merger option.
It would take something more than you saying you'll pursue it. I'd like a resolution from the boards
Presumably accomplished, yes.
that establishes that you're going to head in, I would say maybe both directions, of a thorough exploration of both options.
Don't you want us to go beyond exploring?
I do want you to, but I want you to take steps in that way. I'd like to know about conversations with your state legislatures or your report back to us. Again, I can do it on good faith.
That's clearly what we're going to do.
I can do it on good faith if I, get the warm fuzzy feeling that you're operating in good faith.
I would hope you would understand that we're operating in good faith.
All right, I'm going to, again, what's the
Do you
board's
really think
preference?
we're misleading you? So that,
No, I just don't think you're I don't think you're answering the
That would be
question.
rather foolish, wouldn't it?
Well, I heard, what you just said is our first step would be to get a lobbyist. So,
Yeah, that's what I would do if,
Right.
if I were moving
But-
that there. It'll cost
right,
us a
but
fair
what
bit
we,
of money,
but what I
we'll
think what Mark was saying was, an application submitted to merge, or, a resolution that said, we are working toward separating these boards, and we want to have, a management agreement or an operating agreement that has these, the following broad strokes. That's not what we're hearing. What we're hearing is that boards are not going to do that work. They are going to look immediately toward a fix around the reality of what's going on the ground, and that's concerning to me.
No, it's not a fix around. It's what we see as, we don't believe there's a violation of anything, by the way. And it certainly permits us to continue to operate as we have in the past, but as a merged entity. That's what we would prefer to do.
But then I think it's, what we've said, and we will certainly, all of us let you know officially, but I think then you're asking us to bless that in a way that we are not comfortable.
I would make a motion to the board that we table the discussion about the building and ask the cemetery boards to present to the division your plan for achieving these goals of either separation or merger. And we can take a look at that again next month. You present us to a plan that we deem sufficient. We'll take a look again at the separate issue of the board. of the building.
To be clear, usually present to the division means present to me. In this case, it will be to present to Chet and Tony.
Right, right.
That's fine.
Okay, have that motion? Second?
Second.
All in favor?
Aye.
Aye.
Thank you. I don't know if you have to motion to table. We motion to table.
No, that's fine.
We are asking the cemetery to get back to us with a plan to resolve the issues of the identical cloned boards, either through a plan for merger with some steps where you would be able to document your progress towards your goal, or steps towards separating the boards sufficiently to be able to have mutual agreements between the two. Thank you.
Thank you, Mr.
Thank you
Becker.
for your consideration.
All right. Now, we have people, things to do. Anybody need a break?
Just want to make sure.
Okay?
I'll take a break.
You'll take a break? Yeah, sure. Okay, we're going to take a 5-minute break so that everybody can go to the bathroom. And the doors can open and fresh air can come in. I don't know where all the hot air came How's your colleague doing? She all right? Colleague okay?
She's good. She's good. I think she's just,
She probably really needs a drink.
no, she's just, I think she's letting them know that she's going to be making a later train.
Yeah.
You don't happen to know where Kate lives, do you? 'Cause it's north of the city. I could give her a ride.
All right,
Yes.
well, fall, I gotta look.
Kate, where do you live?
Where do I live?
Yeah.
In the city?
Brooklyn or?
Nope, Manhattan.
Oh. Then I don't know if it helps you any, but if you wanted a ride, I could give you a ride to Westchester and you could catch the metro north.
Almost
But
all
if
the
you're
way
going to
back
the
to
city,
Manhattan.
yeah, but if you're going to the city, it's probably better for you to just take the train. How do I unmute? Depending on the timing, I might be able to give you a ride to the train, though, so you don't have to cab it.
See where we are.
Oh, we were unmuted. Wait, what is that?
It's just recording, right?
What's that thing in the upper right-hand corner? That doesn't mean we're not.
Camera here. That's fine.
Okay, that's fine. All right.
Check, we're ready for you.
All right, shall we?
You don't need a teenager to figure out if it's before that?
We'll take our
All right,
chances.
we're back on, are we back on?
Back on.
Back from the break?
We need to make sure that the microphone's back on.
It's done.
Oh, okay.
All right, so real quick, because we have people waiting for us, and then we have some lengthy discussions. Vandalism report?
Yes.
I'll do it. There are no new applications this month.
That we're ready, right? I mean,
Right, I mean, well, I don't know that we've received any in the last month either, but there are no more applications to be presented for the board. We are gonna be back here for sure with, almost certainly with Oswegatchie and Foxwoods in November, the one that we tabled last month. To date, we've collected $101,941. Our appropriation, as we discussed last month, is $939,000. We have granted $1,472,383 in applications this year, of which a significant number we previously informed everyone that were granted subject to availability of funding. And we have another 1.567 million pending. That doesn't mean that we're going to recommend approval of 1.567 million, but that's what they're asking for in total.
Oh, and yes, sorry,
Yes.
there's board orders.
Our board orders were, we didn't have board orders for the last month's meeting because the language had to be customized to reflect the unavailability of payments. We have done that customizing.
19 to be signed.
20.
20?
Yeah, there were 21 applications. There was one
21,
that we didn't
right.
approve.
So those are for each of us to doodle while we're going through this exercise.
And that's the vandalism report.
I have a question.
Okay, go ahead.
Within 90 days of receipt of disbursement, the cemetery shall make a report to the cemetery board setting forth the repairs made and by whom. This applies to vandalism, abandonments, and restorations, right? Is that another function that we have delegated to the division?
Must be, because since the 10 years I've been doing this, I've never seen those reports come to the board. They've always gone to.
I mean, we've only reported it to you guys if there's an issue. If things are getting done as a matter of course, we take it. But you're right, in the list of delegations, we should add that.
Yep.
All right,
Unless
that's
it's just an
One thing I
oversight.
do know,
an action item.
whenever we do get an application, there's a spot on the form that says, have you previously received
Yes.
money under this? And have you, I forget what the last part is, have you returned any unspent funds or something like that?
But we do in
So-
the staff report, it says that section, right? The past grants and,
Does it?
I'm sorry, repeat that?
on the application, we do report on past grants and if a cemetery is applying for a new application,
We'll generally note it, yeah.
you'll note previous,
All right.
so that does get supplied to the board in that staff report.
Yes.
Has any money ever come back to the
On the same on the same thing?
No, if you're on an application where they ran under budget.
Yes,
It's,
we've had a couple.
it's rare, but we have received.
We had one maybe
Small
2
amounts
years ago,
back,
I
yeah.
remember. There was an overpayment and they paid.
And part of this, the administrative strum around the appropriation and running up against that is taking a look at any place where somebody might have said, well, I did it under budget,
Right.
or that project never went forward, or whatever. We haven't found much in that way. It hasn't really generated enough income for us to solve all our problems, but we are looking at those issues, so.
Thank you.
Any other questions about the vandalism fund or that? Okay. I think we have Beverly Hills on the cemetery on the agenda, and.
I don't know how you want, whether you want them to go first, or I had one very small comment to add.
Well,
to
we would
this
certainly
report.
defer to
It's very short.
Division Director.
We got we received, I'd asked the cemetery to get us, if they wanted to respond to our, I revised my memo on this project slightly after we got their last submission. I asked them if they had anything to say in writing to get it to us by a week ago Friday. They did. I am not going to revise my memo again. I think we've already adequately addressed pretty much everything they've said in their most recent submission. The one thing I'll clarify is Mr. Fryman talks a lot about the certificates and the issue of conditioning approval on a paid down schedule for the certificates. I want to just clarify that while, yes, we would like to see a plan for these certificates to be paid off, and we would like the cemetery to now be operated by its lot owners and not by the certificate holders who happen to largely overlap with the sellers of this land, there's a separate issue, which I did flag in my memo, I just want to repeat it, that right now the cemetery is carrying roughly $4.2 million in debt on as compared to a permanent maintenance fund of about $6.1 million at market, at cost, $6.2 million at market. To that, this transaction proposes to add another $2 million in debt. So the issue with the certificates is twofold. One is the issue of control and the fact that they seem to never be going to get paid off. The second is there is already way too much debt here, and to that we're adding more debt. And I think I made that clear in my memo, but I just wanted to reiterate that that is a concern we have. One of the big part of the concern we have with the certificates is that there's debt upon debt upon debt.
Okay. So, Mr. Fryman, I think what we're trying to do here is give the cemetery an opportunity to, again, represent their view. The board can have a conversation about that. I think we probably will, adjourn later to executive session to have advice from counsel on the matter. But there's a public discussion as well, so it's your time.
Thank you. And the opportunity is appreciated. Thank you.
All right.
Do you want to identify who's with you, please?
Gentlemen can introduce themselves.
Yeah, thanks.
Aaron Chipper, president of Beverly Hills.
Patrick Seeley with Eastover Jones Hacker Murphy, representing the cemetery.
I want to, okay, Louis?
Yes.
I want to, first I want to thank you, members of the board, for agreeing to adjourn this matter to the September meeting so that I could recuperate.
Any details about your surgery is welcome.
That's okay, it was rather boring, but.
All right.
That's the way it should be, right?
Yeah, right. Thank you.
Mr. Fryman, I'm sorry, will you just introduce yourself again in your capacity that?
I'm Richard Fryman, and I represent Beverly Hills.
Okay, so you're both here representing the cemetery? Okay.
So thank you.
Yeah, you're welcome.
Last week, as Louis alluded to earlier, there was a conference, an annual conference at Lake George, hosted by the New York State Association of Cemeteries. And one of the significant topics that was discussed at that conference was the rising problem and issue of abandonment of cemeteries and how it's going to be dealt with respect to cemeteries who just simply operators walking away and leaving it to the towns to operate them. That unfortunate rise of abandonment in cemeteries is a concern, I know, to this board, as well as to the municipalities around the state. With this application by Beverly Hills, we are trying to avoid being caught in that scenario. Because the clear fact is, and it's undisputed, this cemetery is running out of land, and it's running out of land rapidly. And at the present level, if they run out of land to sell, the existing permanent maintenance fund cannot support the cemetery moving forward into the future. The only thing that can keep this from happening is this purchase of land, this opportunity to buy the adjacent land for the cemetery, so that we can continue to operate in the future. From the 1960s, going back to the 60s, this cemetery didn't have the money. I think even Lewis admitted that in review of things during the last meeting was election. The sellers had the foresight to buy that land, knowing that the cemetery one day would need it. And for that intuition, the sellers, in our opinion, have been vilified. And the only thing happening to ensure the success of the cemetery in the future, forgive me, I'll just keep it. The only thing that's going to stop this cemetery from continuing its success in the future is that it's going to run out of land. Markets, trends come and go, but this cemetery has been thriving for many reasons. One is that it's been well managed over the years. It's maintained beautifully, and there have been hardly any complaints by lot owners of the maintenance of this property. Another major reason why the cemetery has been so successful is that it's tapped in to a certain market, and that is the Asian market, where people have been coming to buy graves in mass societies, sort of like the Jewish societies going back, way back when. Societies have been coming and buying land in large quantities, so that they have burial areas for their members of their organization. These bulk sales of the land are key to this particular cemetery and the financial soundness of it in the future. This application goes back almost 4 years now, way before I got involved with it, but it has its roots going back about 4 years now. And over time, obviously, the terms of this proposed sale have changed and have morphed. And the cemetery is now in a very unique position to purchase 55.5 acres of contiguous adjacent land, so that all of its boundaries are contiguous, and that allows for the streamlining of maintenance of its grounds going forward. This opportunity to purchase this land for $2.8 million, which is the proposal pending before this board, has to be approved for this cemetery to survive financially and not become another statistic of an abandoned cemetery in the future. The terms of this deal, which you all know or should know by now, there's an $800,000 down payment coming out of the general fund, which is less than half of the amount presently in the general fund. There is no money being borrowed from any trust fund for this transaction. The remaining $2 million of the purchase price is being offered, in essence, as an interest-free loan by the sellers to the cemetery. There's no guaranteed term of repayment. The repayment happens as the land is sold. That's it. And if the land doesn't get sold, the sellers don't get their money. Quarterly payments are made to the sellers only when the land is sold, and when it is sold, they'll get it quarterly. The financial needs of the cemetery will trump the sellers getting their money. So if the cemetery doesn't have money and they can't make the sales, they can't make the payments to the sellers, the cemetery keeps the money for its operations. There is no acceleration of payments in the case of any default. Contributions to the permanent maintenance fund, which is the goal to build this fund up so that it can survive and the cemetery can survive in the future, are going to be made on the sales of this new land at 15% instead of the statutory 10%. The PM fund is now at approximately $6.2 million and will increase, our projections are it will increase to $24 million over 50 years. More than enough money to maintain and support these grounds going forward in the future. Without this land, the town of Putnam Valley won't be happy taking over this cemetery in the future. We estimate, I believe the division has estimated, giving us a number of 700 graves per acre. That's roughly 35,000 graves being created by the purchase of this land. And I'm including in that the 7 acres of wetlands that our engineers believe they can correct that situation and they'll be able to be used in the future. But I'm not even including that in that calculation. Most importantly, the entire proposal is contingent upon approval from the town for the change of the zoning to cemetery use. If that is denied, the deal is off, the cemetery gets its down payment back, and what will be will be. And perhaps Putnam Valley might be willing to approve that zoning because they don't want to take over the cemetery in the future. That's an argument to be made to the town of Putnam Valley. These are the terms. There's obviously a related party transaction here, and that's been a concern, and rightfully so. There's been increased scrutiny here, and no one is disputing the obligation of the board to do so because of the related party transaction. The fact remains, however, that there would never be another seller willing to give this cemetery the terms that I've just outlined if it not were these sellers. And I believe it's because of their prior relationship with the cemetery. And the cemetery the sellers had acquired this land years and years ago when the cemetery had no money paid for it, let alone take salaries out for them. Sellers are offering these terms at a sale price that is less than any of the 3 appraisals that have been submitted to the board in support of this application. This proposal to purchase cemetery land has been appraised by 2 of the 3 appraisals as cemetery land, not for housing, not for anything else, because the appraisal has to be, it doesn't mean anything on paper unless it's appraised for its intended use. And the intended use here is for it to be as a cemetery. The 3rd appraisal was for a different use, and Mr. Burns was here in July discussing that appraisal and how he came to those conclusions, and how he believed that the appraisal was in essence far more than the $2.8 million purchase price here, and that was for use as a senior residence or development for a senior residence project. He explained the basis for it, for his appraisal, and how he came to those conclusions, and those numbers were never rebutted and have never been rebutted, nor have the other proposals been rebutted. Instead, Mr. Burns was attacked because his appraisal report was written to one of the certificate holders as opposed to a non-member, a non-family member of the board. It's irrelevant, and I refer the board again to the case which has been cited in the papers that we've submitted to you of St. Agnes, where these appraisals submitted have been approved for use in the past. There's a potential windfall here to the cemetery. The board is only apparently what's been said, and I'm not saying the board because the board hasn't said anything or acted on this, but what we've been told by division and by council is that they're focusing on an alleged windfall to the sellers of this land. I propose the windfall here is for the cemetery. And division has been aware, I know, for many years since this happened, of pending contracts with societies. One of the 2 is signed, and they offered to purchase 4 years ago 1,000 graves at $1,500 a grave. That was the Yu Lin Lin Society, and they made a down payment, and the cemetery has been holding that down payment ever since. And I have copies of that proposal for the board and division and council, which you can pass out. That was, a society was going back to 2014.
You'll note that we received it.
Thank you. Just last week, the cemetery has received another contract of sale and signed with a Crown deposit check for another 1,000 graves sold for the price of $3,000 per grave, which is now the stated, the listed bulk sale price with the cemetery. And here's copies of that proposal. This just came in last week.
Okay. Well, note the receipt of the second contract. Oops, yeah.
There's another contract that a number of years ago that was not signed yet, but with similar numbers. We're looking here at a total of $3 million for a small fraction of the approximately 35,000 graves that are going to be sold. We're talking about maybe 3,000 graves, and there's going to be 35,000 more graves to sell. Those contracts alone pay for the entire purchase price and then some. The only party here that's going to be benefiting from this is the cemetery. The cemetery, in essence, is paying about $80 a grave, and we're selling them now for $3,000. In July, before that meeting, it was about a week before the July meeting, we received a copy of Division's recommendation to deny the application. And 5 reasons were listed in that memorandum. The cemetery responded to 3 of those 5 items during the July 25th meeting. The fact that there was an issue about the price list not being posted, it's agreed that's been taken care of. There was a question of consideration of alternatives and whether or not the board members, the independent board members had considered alternatives to this transaction. The minutes, the application that we've submitted, and there were minutes to support it, they did, in fact, consider alternatives and decided that this was the best way to go. And in fact, we had Mr. John Wilshans on the phone last time to give testimony, who has many, many years of experience in cemeteries, saying, I want the cemetery to buy adjacent land. I don't want land down the road where we have to run around splitting up crews and maintaining property elsewhere. This is the best deal for the cemetery. I thought that was put to bed. Apparently it wasn't in the last meeting. And then we had the appraisal issue, and I said John Burns appeared and explained his proposal, his appraisal, and appraisals in general, and supporting his numbers. That was more than the cemetery is being asked to pay in this transaction. The 2 remaining items being asked for discussion in that memorandum from Division talked about the cost of rezoning and the certificates outstanding and the interest on the certificates. And we asked at that time, let us respond to that in a number of days, and we'll give a response. And we did. The rezoning cost. Real Estate 101 says that a buyer of land pays for the rezoning cost in any deal. Nevertheless, we went back to, the cemetery went back to the sellers and asked them to consider an alternative. Division's response was we want the sellers to bear the cost of that, which is not the way it's done in real estate. They came back and they said, all right, if this deal goes forward, if we get the approval, we will agree to pay half. So there's no question here that everybody's keeping in mind and trying to keep clear that no one wants to run amok with paying expenses to try to obtain the rezoning. The seller's going to be paying for it, the cemetery's going to be paying for it. If it can't be done, the plug will be pulled, and that will be the end of the application. The other issue was the certificates. Division had asked whether or not the certificate holders would agree to take out their interest every year so that it doesn't accumulate. And again, upon approval, they agreed that they would take that interest money out every year so that it doesn't accumulate any further. And with a caveat that even if the cemetery didn't have the money to pay the interest in any year, the certificate holders won't get their interest, and it's not, and it's going to be waived. The last part was whether or not the certificate holders would agree to pay down certificates. Again, after negotiation with the sellers, the cemetery came up with a plan that they said the sellers agreed to pay down $500,000 of the $2 million in certificate indebtedness over a number of years. It wasn't going to be taken out overnight. No one wants that, but that offer was made. Now, fast forward to 5 days before the last meeting, before I got laid up, and there was another list of five items in Division's memo that were outstanding. It's like a theme. There always has to be 5 items in this memo.
Odd numbers work.
I think it does. I like 3 better, but that's okay. 1 would be perfect. One item that's never been on the list before appeared, having to do with administrative expenses. This was reminiscent of the procedure that we went through, first with Division and then with Council, where every time questions were asked, we'd give answers to them, and then 5 more questions would follow. And you never knew where this was coming from. It was almost like a game of whack-a-mole, except this isn't a game. This is the cemetery trying to buy the land to ensure its survival. So I've addressed the issues in my letter dated in September 28th. Many of the items that are there have been dealt with. Why we're still talking about whether they were alternatives to this proposal were considered by the board is beyond me, but it appears again in the memorandum. It's abundantly clear to the cemetery at this point that no matter what is offered, Division and Council will never recommend this deal to the board. What we've gotten instead are accusations of an alleged 50-year fraud scheme that the sellers perpetrated, that they knew that they would buy this land and somehow 50 years later they would sell it to the cemetery. And accusations that they're making money on that investment. 50 years ago, back when I grew up, my house on Long Island cost $22,500. Back in that time, you could buy a new Buick for $3,000. Those times are gone. Those times have changed, and it has nothing to do with the present application before this board. What it has to do with is what is a fair and reasonable price for the land. Then we get the demands about the certificates and the interest and paying down the certificates, which in my view are nothing more than some type of seeking some type of an extortion or a bribe to agree to get agreement from parties to agree to this deal. It's unfounded. It should not be condoned, and it is lacking in any statutory authority to do so. So the cemetery is asking the board to review this application and focus on what should be considered here. Is this deal in the best interest of the lot owners? Is this deal in the best interest of the cemetery to ensure that it continues going forward in the future? Will this proposal benefit them in the long run? Will it ensure the financial stability of the cemetery in the future? The last time I looked, no one's creating more land to sell. This is their opportunity to buy it. This is their best and only chance to acquire that land. To acquire that land. Denial of this application, in my view, and pardon the pun, signs the cemetery's death warrant. And it ensures that in 6 or 7 or 8 or 10 years, when we run out of land, the keys are turned over to the town of Putnam Valley, because the cemetery cannot sustain itself without this land and the sales that will generate the income to support the cemetery going forward in the future. I view it a denial of this application as an opportunity lost. I can imagine a board, Lord help you if you're still sitting here 10 years from now, but if another board is sitting here 10 years from now, or if members of you are still here, somebody would scratch their head and say, how did this happen? Why did this happen? Why are they asking now why is this application for abandonment pending? And the answer is because the opportunity was lost when it was available. I implore the board to look at the facts, to look at the terms of this offer that are, that the statute talks about, that you may look at the terms to decide whether or not this is in the best interest. And those terms, as I've said more times than you want to hear me say them again, are terms that you could never get from any other seller of land in this scenario. Don't let this discussion be about who the sellers are. Don't let this discussion be about the rights of certificate holders. Don't let this discussion be about the appraisals or attacking appraisers. Do let this be considered about the favorable terms as the statute asks you to look at. Let it be about the possible windfall for this cemetery to ensure its financial survival into the future, which, as you can see, has already started if this land deal is approved. And if it doesn't, we don't have the land to make these deals. Let it be about the cemetery becoming financially independent. Let it be about the lot owners so that the cemetery can survive. Thank you.
Thank you. Anybody else wishing to speak to this issue?
I have one question. I'll let you guys go first, though, if you have anything. What discussion has the cemetery, or if you know, the sellers had with the town as to the possibility of rezoning?
I think this was BR before Richard, but my understanding is that the town wouldn't address it until the board approved it. They don't want to put the cart before the horse.
I also just wanted to clarify what we said about it, the level of administrative expense has been in our memo all along, in every version that's been shared. I think I did a bullet point on it just for clarity, because I think it kind of got lost tailing off at the end there, but I didn't even touch that section in any of our revisions.
And your statements also say how the administrative expenses have gone down. I don't know why it became a bullet point.
That
That's
is
okay.
correct. That is correct.
Maybe it was that 5 number we needed.
It is correct that one of the biggest expenses we're concerned about was eliminated after we raised it.
Which is great, because as I said, the deal has gotten better and better over time. It's not going to get any better.
Well, one thing, and I think it's fundamental, and it's like it's been in place throughout the iterations. So I'm going to talk about the appraisal. You mentioned that the way it's done in real estate is that, the buyers pay for the cost of rezoning. And I think, given that that's the case, it's incongruous then to present an appraisal where the value is based on assumed rezoning, right? If this is vacant, land, which it is now, that's how it should be appraised. We've talked about, or you've talked about, you've presented us with, a case that discusses how to value cemetery land. And I don't think I know that, in the context of that appropriations case, that land was valued as cemetery land because it was cemetery land, and it was zoned as cemetery land. And, not that this is necessarily, I'm not speaking on behalf of, the other board members, and it's not necessarily dispositive, but I just think it's very important to be clear that what we're talking about and what we're being asked to approve is an appraisal of vacant land.
For its use as a cemetery.
But the case that you cited, and
It's the only case we could find.
But it's the case that you cited actually speaks to the proposition that we appraise land for its current approved use. And St. Agnes was approved, it was a cemetery and valued as a cemetery. What we are saying is that we haven't seen an appraisal yet that values this land for the purpose that it is zoned.
May I, Richard?
Yeah, sure.
You have in front of you two separate contracts that total, I believe, about $4.5 million for purchases of graves once it's approved. That's $4.5 million for something, I don't even recall how many acres that adds up to, but it's got to be less than 5 in all of it. So you've got proposed sales of a piece of the subject
Yes.
property that, once approved, would more than back up those appraisals.
That doesn't
Right.
make it fair market value, though.
Well, there's an issue here then, when we're talking about it. When you look at vacant land, you're supposed to value it according to its highest and best use. Any appraiser will tell you that, right?
As highest and best use, given the zoning.
Correct. And so what we're saying is that it's not just the appraiser who's pulling these numbers out. We have actually parties who are willing to spend that money. Yes, there's the issue of getting it approved, and that's being addressed by the who's paying for the rezoning costs.
But again, if it's such a non-issue that we are all assuming that it's going to be rezoned and that that's not a big expense, it's not a big time factor, then I think as, you know, to me, I have a problem with it. You know, either it's rezoned, in which case, you know, sellers spend the money to get it rezoned, or value it as vacant land. I mean, I don't see how you have it both ways in terms of, you know, which interest you're, you know, which hat you're wearing. I think it's not consistent.
Right. What you're saying is you want a risk-free transaction
No.
for the cemetery.
What I'm saying is,
That's what it sounds like.
no, what I'm saying is that it's
Well, that
very-
would be ideal.
It's very clear in the case law. I mean, I think it's a pretty, you know, black letter that in terms of appropriations, which is the line of cases that, you know, we're talking about, the appraisal is based on the current zoned use, right? And this is vacant residential land. So I hear what you're saying.
Actually, some
that-
of it used to be cemetery land.
but it's not cemetery
not
land
anymore.
now. So, and the difference, if that were zoned, if that were valued as in its current use as, you know, vacant residential land, we're talking a factor of, you know, 3-4 times its fair market value with what you've presented us with. And that's just a fact.
Agreed, although I will point out to you, at least when we're talking about highest and best use, it's what the property could be used for. So that's where the approval factor comes in, right?
Right.
If it gets approved.
If it was rezoned, correct.
It's terrific, right? The money comes in, there isn't any doubts. And that's
Well,
why you have the splitting of the cost between the buyer and the seller.
I mean, another way to state this is that neither of the appraisals that appraise it as if it were already assume a can opener and open the can.
One of the appraisals does offer the discount.
Which one?
Because it's not
Which
zoning.
one?
The American appraisal, the appraisal consultants. There's a 15% discount. We've dealt with the net.
I guess another concern, again, regarding the appraisal, is I know that in the past, and again, this was a fairly remote past, so the landscape, no pun intended, might have completely changed, but I know there was a previously rejected request to rezone. The town had rejected a request to rezone some land in the past, no?
Not that I'm aware of.
Okay, there's a line of cases
There- I
with
don't
Beverly
think
Hills
it's ever been-
Cemetery.
It's never been, as far as I know, denied.
Okay.
How much land does the cemetery have now?
That's correct.
It's 96 acres.
So the 5 acres,
55.
the 5 acres it would take to take the 5,000, all those graves out of your 95? You could take all the current contracts and fulfill them?
No, there's not enough currents. There's not enough land right now.
There's 95 acres.
You have what, about 6 acres left?
Okay, so I thought you said 95 acres. Yes,
No, no,
you're
no.
right, that's the total.
Total.
Yeah, it's 6 acres.
We
That's what I
have
wanted to know.
graves scattered throughout the cemetery, creating inventory. But sellers like these want to buy
Yeah, I
contiguous.
understand. So I was
How much
asking
have
how
you
much
got left
vacant
that's
land you have.
contiguous?
There's one section that has as much as 600, maybe maybe a little bit more.
Okay.
Thank you. And just let me point out, I mean, this is obvious, but the cemetery is only engaging in this transaction, it's only purchasing the land once it's rezoned for cemetery land. Right? So, I mean, I think that's extremely significant. That will be obviously the intended use. If the zoning is denied, then the transaction.
I have a question. I don't think I've seen, because you raised a concern that without the additional land, the cemetery would not be able to continue to operate. But every cemetery is expected to have sufficient PM to maintain the cemetery into perpetuity. I don't remember seeing any kind of analyses of what the cemetery's operations would cost in a scenario where there is no more graves to sell, and that it is a matter of just maintenance and preservation. So generally, you would see a reduction in expenses based upon that status.
I'm sure there would be,
I
because
didn't
there's no
put-
sales force anymore.
Correct, but I don't recall seeing an analysis of that. That's number one. Number two, you're saying it could be a windfall for the cemetery, but of, say, the potential $3 million contract, only 10% would go into PM, so that's $300,000.
15%.
15%?
I said that, the terms have been changed, so that we can put in
Okay.
more
Okay,
than the statutory requirement
right,
of the sales of this land.
right. Okay, so it's 15%. Okay, so then again, I don't think I've seen any kind of analyses as to what kind of income that additional funding would generate into perpetuity, to maintain the cemetery. So, I mean, there are facets of this I don't recall seeing, so.
I believe in one of the many cover letters to the various applications, this was dealt with, and sort of back of envelope calculation. If we've got today $6.2 million, if you could get a 5% yield, on that 6.2, that's about $300,000 a year. Present maintenance costs are $700,000 or so, without any admin costs. So you still will want to have an office open and so forth. The cost of maintaining the additional land is not hugely significant because we already have the expensive equipment, the staff and so forth. And the trust fund will grow primarily because in the past, when we sold graves for $300, $30 went into the trust fund. Now when we sell graves for $3,000, $450 will go into the trust fund. It's much more substantial. So our projections are even without growth from equities and so forth, those are just contributions will increase the fund significantly.
Can I ask, who's the attorney for the sellers?
Jerome Katz, you met him.
Okay, it must have been years ago, because
No, it was when we had a meeting in your offices, an informal meeting.
is that
When
when Bob
Dan-
Abrams came as well?
No.
Okay.
No, this is the one that Dan arranged, where you, me, and Dan met with their attorney and Mr. Fryman and Mr. Shipper.
Jerome Katz and
Okay, I probably haven't heard from him since then.
Well, yes, you asked questions during your inquiries for documents and information from him directly. Because I know I
No, I'm
gave
just-
that information, I gave you the
I'm
contact.
just surprised that the cemetery is now paying for two attorneys to represent it on this.
Well, one is here on valuation issues, because that's a lot of my background, and I'll also handle any litigation if it comes to that.
Yeah, I thought you were here to
There's a-
sue us.
there's a-
Okay.
There's a division
Gotcha,
of labor
gotcha.
there.
All right. So the other thing that strikes me is the representative for the Attorney General's office indicated that perhaps if this were evaluated, the land were appraised as vacant real estate land, that it would be valued substantially less than the three appraisals you submitted. In fact, I think she mentioned a multiplier of 4 or something to that effect. Normally, I would expect representatives of a cemetery that's paying for the land to jump at that and say, wow, we're overpaying, let's go back and renegotiate. Instead, I hear the cemetery representatives defending what may be appraisals that are requiring the cemetery to pay 4 or 5 times what it would be if it had been appraised as vacant real estate land. I'm confused by that.
Well, I think Richard said it during his presentation, that this is the last best chance. The sellers don't have to sell if they choose not to.
So it's a position of the cemetery that this is a price that is above fair market value, but it's the best we can get.
No.
No, not at all.
Okay.
There have been extensive negotiations with the sellers. This is a purchase price and terms that I never thought we could get from the sellers. And the sellers themselves care less about the appraised value as real estate, and more about recovering their very substantial expenses they've had over the years, paying real estate taxes, et cetera, for in some cases up to 50 years on the land.
Well,
And again,
and
I mean, I'm
that
talking,
brings up-
we're separating here, as Andrew said, the purchase price and the terms. And the terms are such, as I've said, that no seller would ever get, no other seller would ever get. And that has to be included in the calculation.
So are you suggesting that the fact that the repayment terms should be considered, and I'm going to put this pejoratively, you probably wouldn't mean it that way, but are you suggesting the board should think of the fact that repayment is contingent on sales as somehow mitigating the fact that the appraisals are high? I'm not expressing it well, but I think, but you see what I'm saying? That that's a factor that should give the board more comfort in the price as presented. Is that your position?
No.
May I, your charge is fair and reasonable market value in approving a
Right,
transaction.
exactly.
And that you may consider the terms as part of that, right? That's what's in the statute.
Okay.
And so
I get it.
we would submit that that would be part of your consideration on it. But also further is that we do have interested bulk buyers who are willing to pay substantial sums of money for fractions of what this whole piece is. I mean, that's a pretty good indication that, again, you're right, approval's not assured, but we think that the town would, in the scheme of things, consider what they're looking at in the alternative and realize that approval's a pretty good idea.
And Mr. Freeman, just hopefully my last question. You mentioned that the board considered alternatives. Would you agree that the documents you've given me, the only alternatives that appears that they've considered is asking the sellers to sell less land, that they've never retained the services of a real estate broker or agent to go find land and get them other possibilities other than the
We
land
have
owned by
stated
them?
in the past that the sellers, my understanding from the sellers is they will not sell less than the total amount of land.
But that is the only effort that was made when you say.
Then you heard testimony from John Wilshans during the July 25th meeting, where he said that, as president of the board, that this deal for this land is the best thing for the cemetery. I don't want land 2 miles down the road. And this is the only land that's contiguous to the cemetery.
So that was never considered.
What was good? Land 2 miles down the road?
Yes.
He considered it and said, I don't want it. I'm not saying that he looked at land that was available.
Right.
He's saying the whole prospect of it is a nightmare.
Okay.
And I don't want that. That's what he said.
Thank you.
Any other questions? It's before the board, your application before the board, and I assure you that our interests are the same, is to make sure that the interests of the cemetery are met, and lot orders are met, that's what we're here for, and that the property is acquired at the fair and reasonable price. So those are the things we'll be considering. I don't intend to have, I'm not sure we'll have a decision today. We may come out of executive session with a decision, a discussion on the decision, but I'm not 100% sure of that, so you're welcome to.
How long does the executive session?
I think we have kind of a long one, and that's not intended.
No, I
Not just you, there's another significant item on for executive session that's going to take a lot of time.
I think I heard that part on the speakerphone.
That's not it.
Oh, okay.
Another one.
Oh, Lord, there's more? Okay.
All right.
We may, or.
You're welcome.
Thank you.
You're welcome to
Thank
stay.
you for the invitation.
Yeah, come on a long way.
Get out of there and we'll give you a call.
It's up to you. Come a long way.
The other thing is if we are going to come, if you want to not hang out somewhere out there, but go somewhere else, I'm happy to call you on your cell if it looks like we're going to do
It's fine.
that.
Okay. Well, hang on, Lord knows I don't want to sit here for 2 hours, but I will get something to eat or drink.
Well, you can't sit in here for 2 hours. You wouldn't want to sit out there for 2 hours either.
There's a restaurant down at the,
Yeah, yes, great.
so thank you for your testimony, thank you all for that, we appreciate it. Next on the agenda is public comment. Is there other public comment for us today?
Helen, you got anything? All right, next meeting.
Next meeting date
Schedule.
is already set.
It is November, 13th, I believe. November 13th at 10:30 in this very room.
Okay.
Like it
Can
always
I have
is.
a motion to adjourn to executive session? We have legal matters and council's opinions to discuss. Can I have a second?
Motion to adjourn, second.
All in favor? Motion to adjourn to executive session. We will come back out of executive session to either adjourn the meeting or to take up other topics.
We are going to lose our recording by then, I believe. So if we do come out, we're just going to have to take good notes and report it.
Okay.